Good afternoon, everyone. This is Richard Aikens here at Brick Court Chambers. We're just waiting for a few more people to join in, so we shall start in a couple of minutes. But whilst we're waiting, perhaps I can just say a few words about this webinar. It's concentrating on shipping and international trade, but it's looking very much at financial aspects of it, and it's concentrating on how fraud can have an impact on commercial activities in international trade. So the title, unofficial title, is Fraud Unravels All, True or False? And it's a common saying in cases that fraud unravels all. Lord Bingham once even used the Latin phrase, which he either invented or found from some old case, which he put as fraus omnia corrumpit. Literally, fraud corrupts all. Well, what we're exploring in this webinar is whether or not that statement by Lord Bingham is true or false in the various settings that the three speakers are going to talk about. Now, if Paul Gray thinks it's time to proceed and it's just a minute after 1 o'clock, I shall introduce the first of the three speakers. Paul, are you happy that I do that?
Yes, absolutely, Sir Richard.
Good, thank you very much indeed then. Well, the first speaker this afternoon is Richard Lord. And Richard is a specialist in shipping and international trade disputes, and he has been since he arrived in Chambers in 1984. He's had to live down the fact that he was my pupil to begin with, but he's overcome that disability very easily. He has an extensive practice covering all aspects of dry shipping, international trade, and marine insurance. And in that respect, he recently changed the course of marine insurance law with his famous victory in the Supreme Court in the Vers-Luth case. He's written and lectured extensively on the subjects, and he is a co-author, together with me and two other members of Brick Court Chambers, of a book called Bills of Lading, which is now about to enter into its third edition. Richard is going to cover two topical instances where bills of lading can be used as tools of fraud, frequently in conjunction with letters of credit and letters of indemnity. Richard, over to you.
Well, good afternoon, everyone. I hope that you can see me and hear me. And like everyone else, I suppose we are adjusting to the new normal and the idea of speaking to those we can't see, we can't hear their groans or see their heads in their hands. But without further ado, I'd like to say a few words on the subject of bills of lading as tools for fraud. That might be seen as a bit unfair to bills of lading to emphasize that. These are versatile documents which have developed over the centuries almost entirely by the commercial interests and merchants to meet their needs as opposed to statutory intervention. Similarly, the law on that reflects that. And no one could deny that they're vital instruments of commerce, but almost by the same token, they can be used as instruments of fraud. And indeed, some observers have expressed surprise that there is not more fraud in their use. And in contrast to other valuable bits of paper like banknotes, they're not that difficult to forge if you're so minded. Most of them are simple bits of paper with two sides, often authenticated by nothing more than an illegible signature and of the stamp of the sort you could get for a couple of pounds on Amazon. But they are, of course, fraud is a minority of cases, but significant for those of us who litigate these matters. And in the time I have available, I would like to focus on a couple of particular types of contemporary fraud, and both of the ones I've chosen reflect the fact that bills of lading are not just things in their own right, but an integral part of the underlying commercial transaction, the sale and purchase of commodities. And none of the instances I'm going to deal with are hypothetical instances that we've dreamed up here or by some law professor. They're all actual examples of things I've seen in cases that I've been involved with over the last year or so. The first type is the improper use of switch bills of lading. This seems to be something of a hot topic in the sense that I've noticed lots of articles being written about it, but as most of you will know, the switch bill is where the carrier issues a second set of bills in place of the first set, and sometimes the carrier is even imprudent enough to issue the second set before the first set is surrendered and cancelled. That gives rise to different issues, but that's not what I want to talk about this afternoon. And often the second set are issued in a different place from the first set, or they show a different shipper, or they show a different place of shipment, or they have a different description of the cargo, and sometimes all of those. And very often this can be for a legitimate purpose because the trader wants to conceal for commercial purposes the original seller of the cargo and so on. But often it's a temptation for unscrupulous traders who want to do things such as avoid taxes or import duties due on cargo by disguising the origin of the cargo or disguising the fact that cargo may be a blend. And the cases are all very fact sensitive. Lots of people sail close to the wind, but the question is when you sail the wrong side of the wind, if that's not mixing my metaphors. And the problem arises when carriers accede to demands by charterers to issue switch bills in potentially inaccurate terms. And of course, the commercial pressures may be significant, both to agree to charter terms that provide for switch bills, sometimes against letters of indemnity, or to do so after the charter's been concluded. And the basic point is that, as a matter of principle, the description of the bill may render the carrier liable in deceit to subsequent holders, and they may be the receiver or they may be the bank that financed the purchase. And these types of cases, although they're in one sense just ordinary instances of the law of deceit, they raise quite a number of interesting questions, or potentially do so. Given that it's a tort claim in general, you may get questions as to the applicable law and jurisdiction. Sometimes it may be said that it arises out of the bill of lading, so is subject to the bill of lading contract and jurisdiction, but it may not be. You may get questions as to the enforceability of any letters of indemnity issued in exchange for issue of the switch bills in questionable circumstances, and cases such the application of the principles in Brown Jenkinson and Percy Dalton that you can't enforce an indemnity to do something fraudulent, and of course deceit comes within fraudulent. And in particular, two factual questions: the question of reliance on causation by the claimant. So some of these schemes involve deception for the benefit of the receiver, some of the tax deception schemes. So there may be issues as to whether the receiver was actually in on it and whether they were deceived at all. And also issues of knowledge by the carrier of the falsity of statements. So some instances are very stark. Obviously, if there is a cargo shipped in Singapore and you issue a bill saying shipped in Hong Kong, that's false. But there are many much more nuanced situations, and in particular, You get instances of cargoes being partly unloaded at a discharge port, then reloaded with a request to show shipment at that new port. That's fact sensitive. Sometimes also you get quite technical descriptions of cargo. It may not be apparent to the master where it's a blended cargo, that's an accurate description or not. And these practical issues come up in addition to quite a lot of legal ones. And just to pick a couple of examples in this relatively fast canter through the topic, what's the legal formulation of what happens with a switch bill? Well, many people say it's a novation, and indeed that's the analysis adopted by a very recent Australian case called Wollongong. I'm not citing a lot of cases this morning, more talking about some general concepts, and any cases we do talk about in this seminar will be available afterwards, so you don't have to go and note, but I'm going to at least mention one new case and one quite old one. So Wollongong, the Australian case, which looks at switch bills and adopts the novation analysis. There are also issues about when the bill is issued in a new place, it may affect the applicability or otherwise of the Hague-Visby rules. But that's really just one instance of common fraud, and that's in relation to the bill of lading itself. The next instance is something different, and it's almost more about the absence of bills of lading than about the bills of lading themselves. And this arises from the practice, which I'm sure is very well known to all of you, that it's very common for cargoes not to be discharged against bills of lading in the classic and conventional system, but against letters of indemnity. That's particularly prevalent in the oil trade, and bearing in mind that often oil cargoes are traded many times between shipment and discharge. And furthermore, it's also now common for letters of credit, pursuant to which payment is made, to dispense with the conventional requirement that the seller presents a bill of lading in exchange for payment, but rather that they will accept a seller's letter of indemnity, different from letter of indemnity against which discharge is made. This is where, in essence, the sellers say, well, we've got title to cargo, we haven't got the bills of lading, but we hope to get them soon, and when we do, we'll pass them on. And why does this occur? Why would banks expose themselves in this way? And again, it's the same old story. It's really because banks are often willing to lend to traders, primarily on their basis that their clients persuade them of their Goldfinger-like abilities. And although in finance terms, almost inevitably, it's a requirement that the bill is made out to the bank or its order and delivered to the bank, actually, under this type of scheme with LOIs, the bank doesn't expect to see the bills for many months, and it's a last resort. And when their client turns out to be slightly less gold-fingered than expected, and it all comes crashing down, a big cry goes up. The bank goes in search of the bill of lading. If it finds the bill of lading, it may want to sue the carrier for conversion, for delivering without production the bill of lading. If it doesn't find the bill of lading, it may want to sue the seller, either in its own right in deceit or as assignee of the buyer, for failing to provide the bill of lading as may be warranted or represented in the letter of indemnity itself. And of course, all of those things that I've mentioned may happen as a matter of bad luck as opposed to fraud, but the same rather lax trading practices offer opportunities to the unscrupulous. So one is by use of forged or fraudulent or unauthorized bills. There are interesting legal issues which we, of course, don't have time to go into between the differences between those three types, which are quite often overlooked. But sometimes traders give particulars of genuine cargoes which have actually been shipped, but use house bills instead of the shipped ocean bills. Again, the receiver or the bank may be able to sue in deceit, and that may depend on who foreseeably might be intended to rely on these statements. The problem of forged bills is, of course, not limited to this type of transaction, but it's much easier to pull off if the bank is not expecting to see the bills for months. And it's exacerbated by letters of credit, which are often in very loose terms, allowing for shipment long after the letter of credit's open, or conversely, for presentation of bills of lading, which are issued long before it was opened. Sometimes you get false bills, but it's not the responsibility of the party who have presented it, it's someone up the line. And so that may involve issues of knowledge of the party presenting it when it's put in a letter of credit context. There's no deceit if there's no intention to deceive. Then another scheme which has led to litigation in this country as well as in Singapore is where the bank is deceived by virtue of the bill of lading and associated documentation as to the nature of the underlying transaction between seller and purchaser. And basically, banks want to finance normal actual sales of commodities, but there have been instances of sellers and purchases dressing up what are effectively finance transactions, sale and buyback of cargoes, where one of the parties is actually not a genuine seller or buyer in the normal way, but is providing finance, but dress them up as normal transactions so they can get the security of a letter of credit. And that again may raise questions as to whether the bank who provides the letter of credit has been deceived. Then final category is that when you only have to present LOIs and not bills of lading, there's an opportunity for traders to succumb to the opportunity of trying to finance, obtain several sources of finance on the same cargo and use the same documents to satisfy more than one set of banks. Now, you might think that that is a hopeless type of fraud because it's obviously going to be unwound, but in practice, where you've got an LOI instead of a bill of lading, it's much easier because the banks aren't expecting to see the bills of lading for a while, and the traders obviously hope that by the time any questions are raised, they'll have covered the sums owing through future profits. So I must bring this to a close, but these types of fraud raise a lot of factual issues, but they also raise lots of legal questions as to the scope of the obligations of the issuer of these types of payment LOIs, their potential liability and deceit to parties, both the counterparty, trading counterparty, and those more remote who may reasonably be expected to rely on them. There are issues of causation and inducement, and I promised at least one other case, and the one that I've always thought was quite interesting, nearly 20 years old now, is the Frager Scandic, where the issuer of a payment LOI of this type was found liable in deceit because, contrary to the terms of the LOI, they did not have good title to the cargo because they'd disposed of it elsewhere, and they'd no intention of being able to produce the bill or producing the bills of lading at some later stage. So that is a trawl through some interesting aspects of fraud where bills of lading, or perhaps more accurately in some instances their absence, is used to facilitate fraud. Thank you very much for listening, and I know we'll have some time for questions or comments at the end.
The intention is that if people do have any questions, then of course they can send them in to Paul Gray, and we will put them to the participants, the speakers that is, at the end of the three presentations. And if there aren't any questions that come forward, then the three presenters may nevertheless have to face a question, but from me in that case. Anyway, Richard, we'll come back to you later on. Now we move on to the second presentation, which is given by another Richard Eschwege. And he is going to cover recent case law on the meaning of payment obligations in a letter of credit and an analysis of the different types of payment obligation and the relevant legal standard that needs to be established to satisfy the fraud exception, to satisfy the fraud exception when resisting an application for summary judgment. Richard is now a leading junior in heavyweight litigation and arbitration, and he has been involved in some of the most high-profile and significant cases in recent years. He has a predominantly commercial practice with a particular focus on disputes in the areas of energy and natural resources, banking, civil fraud, insurance, international trade, and conflicts of laws. Richard, over to you.
Good afternoon, everyone. The court has often said that letters of credit are the lifeblood of international commerce. And save in the case of fraud, the function of the letter of credit is to pay the amount demanded on presentation of conforming documents. Now, because of the separate and autonomous nature of the letter of credit, the liability to pay the beneficiary is not affected by the merits of the underlying dispute between the parties, a dispute which has often been referred to arbitration or to some other dispute resolution procedure. To protect that lifeblood, the court seeks to ensure that, notwithstanding any dispute as to the performance of the underlying contract, the independent payment of the obligation of the letter of credit is not compromised. Nonetheless, the court regularly hears disputes as to the proper interpretation of letters of credit, considers the precise boundaries of those obligations, and determines whether it should intervene in respect of disputed payment demands. Over the next 10 minutes or so, I want to look at some recent cases before the court which have analysed letters of credit and which give some indication of the court's current approach to resolving disputes arising from them. And there are two topics I want to focus on. First, the nature of the payment obligation and what precisely that means. And secondly, the relevant legal standard that needs to be established for the fraud exception. I first want to consider the meaning of a payment obligation. Now, this is an issue which may affect any number of commercial contracts and has potentially wide-ranging application. But it is particularly important in cases of letters of credit because often the beneficiary must certify in the demand that a payment obligation has actually arisen. In a case called Petra Saudi and PDVSA from 2017, Petra Saudi and PDVSA were parties to a drilling contract governed by Venezuelan law. Petra Saudi had issued certain invoices for payment. Those invoiced amounts were disputed, and the relevant invoices were referred to arbitration. The drilling contract had provided that PDVSA was to procure a payment guarantee, and so a standby letter of credit had been issued to guarantee the payment of any of Petra Saudi's invoices. Petra Saudi made a demand for payment under the letter of credit, which was signed by its general counsel. And it said that it was entitled to call for payment of $129 million US. The demand certified that PDVSA was, quote, obligated, close quotes, to Petra Saudi to pay the amount demanded under the drilling contract. At first instance, the commercial court held that Petra Saudi was not entitled to present the demand to the bank and that the demand had been fraudulent. Now, this was because an issue in the underlying arbitration was whether a particular provision of Venezuelan law, Article 141, ruled out PDVSA's payment of an invoice pending the completion of a verification procedure that the invoiced amount was correct. Now, the commercial court considered that the effect of Article 141 was that no debt was due to PetroSaudi under the drilling contract, so there was no obligation on PDVSA to pay a disputed invoice. It therefore followed that the demand under the letter of credit, which had certified that PDVSA was obligated to pay the sums claimed, was false. In the commercial court's view, it could not truthfully be certified that PDVSA was obligated to pay the sums now, because a certificate that PDVSA was obligated to pay a sum meant there was a debt owed to PetroSaudi, which PDVSA was at that point in time bound to pay. But there was no debt unless and until the Article 141 procedure had been fulfilled. The Court of Appeal overturned the decision. For today's purposes, the point of general interest in the Court of Appeal judgment is its discussion of the different types of payment obligation. The questions for the Court of Appeal were whether a certificate that PDVSA was, quote, obligated to pay, close quotes, a sum, meant one, PDVSA was both under an obligation to pay PetroSaudi and presently bound to discharge that obligation, or two, PDVSA was under an obligation to pay PetroSaudi even though it could not presently be compelled to discharge that obligation. And whether the answer was one or two, was it nonetheless open to PetroSaudi to certify that PDVSA was obligated to pay the sums demanded? Lord Justice Christopher Clark observed that the Article 141 procedure provided an excuse to PDVSA not to fulfil an existing obligation to pay under the drilling contract. But it did not follow that there was no obligation on PDVSA until the Article 141 procedure had been complied with. Instead, the court distinguished different types of debt obligation. One, a debt could be wholly contingent, such as it only arises and becomes payable upon the happening of a contingency. Two, a debt can be payable only after a period of time has elapsed, in which case it will not be due and payable until the expiry of that period. Three, the debt can be due and payable now, but there may be some restriction on the discharge of the obligation by the debtor, or the debtor might have an excuse for not discharging the obligation. On the facts of PetroSaudi, the court considered that the debt fell into the last category. Yes, a provision of Venezuelan law imposed a restriction on payment by PDVSA of the sums due, but that restriction did not mean that there was no extant obligation on PDVSA to make payment to PetroSaudi, only that PDVSA could not discharge that obligation until the Article 141 procedure had been complied with. So when the court construed the meaning of the payment demand for the purposes of the letter of credit, it considered that the language, quote, obligated to pay, could refer to the accrual of a liability to pay, or to an obligation to pay which was immediately to be discharged. And therefore a statement that PDVSA was, quote, obligated to pay could mean that the obligation had accrued such that PDVSA was liable to make payment, even if the Article 141 procedure precluded PDVSA from discharging that liability. PetroSaudi was therefore entitled to serve the demand, and no question of any fraudulent demand arose. The analysis in PetroSaudi is a very useful discussion of the different possible meanings of a payment obligation. Of course, ultimately, every document must be construed in accordance with its particular terms and in its unique setting. As Lord Justice Leggett observed in a recent Court of Appeal case last year called Minera Las Bambas and Glencore, because the word payable is capable of different meanings in different contexts, then the particular use of the word in one document and one context is likely to be of no assistance in the construction of the word in another document and in another context. But nonetheless, the PetroSaudi analysis provides at least a conceptual framework for interpretation of any particular payment obligation. The second topic that I would like to address briefly is a particular legal aspect of the fraud exception to the autonomy principle of letters of credit, i.e. that in the absence of fraud, a bank is bound to pay out under the letter of credit. A familiar scenario is that the beneficiary seeks payment, the bank refuses to pay because it suspects fraud. The beneficiary issues proceedings against the bank to enforce the letter of credit, and invariably it seeks summary judgment. A recurring issue for the court has been to try to articulate the relevant legal standard which the bank needs to reach in order to establish the fraud exception defence, at least at the stage of resisting the summary judgment application. This was one of the issues that was considered by the Court of Appeal in a case called National Infrastructure Development Co. and Banco Santander. National Infrastructure Development Co., or NIDCO, was a government vehicle that undertook public infrastructure work in Trinidad and Tobago. It had entered into a contract with a Brazilian contractor, OAS. OAS procured letters of credit in NIDCO's favour by way of retention and performance security. There was a dispute as to the payment for the project. The construction work ceased, OAS abandoned the project, the dispute went to arbitration. In the meantime, NIDCO had issued proceedings against the bank to enforce the letter of credit and recover its security. OAS obtained an injunction from the Brazilian court preventing the bank from paying out any demand. The English court granted summary judgment in NIDCO's favour. The bank had resisted the summary judgment application. It argued that the sums claimed were not due and owing, and NIDCO had no honest belief they were due and owing. It pointed to various pieces of evidence that NIDCO had no honest belief that they were due and owing. Now, the difficulty for the court when confronted by a summary judgment application is that there is a tension, or at least a potential tension, between, on the one hand, the autonomy principle in letters of credit cases, i.e. the requirement that the bank pays out unless there is clear evidence of a fraud, and on the other hand, the relatively low burden on a defendant to resist summary judgment, namely a real prospect of establishing a defence. Lord Justice Longmore observed that the issue had been a matter of some debate between commercial judges over a number of years. At first instance, the judge had asked himself whether the bank's fraud defence was, quote, seriously arguable. But that was to put the test in one sense at too high a level, because the bank only had to show a real prospect. But the question was, well, a real prospect of what? Well, the correct test, according to the Court of Appeal, was whether the bank had a real prospect of establishing at trial that the only realistic inference was that NIDCO could not honestly have believed in the validity of the demands, so that the fraud exception applied. Lord Justice Longmore went on to note that whether or not the sums were in fact due and owing in law was irrelevant to that question, because it's the beneficiary's belief in the validity of the demands which matters, not whether the demands are correct as a matter of law. It obviously cannot be fraudulent to make a demand that one is entitled to make. And even if there's no entitlement in law to make a demand, that does not mean that the only realistic inference is that the beneficiary could not honestly have believed in the validity of its demands. One final point. The bank had wanted a stay of any judgment ordering it to pay in the light of the Brazilian injunction. Well, that was given very short shrift. The whole point of the letter of credit was for it to be honoured in the absence of fraud on the part of the beneficiary, and orders of other courts did not compromise that principle. So what can we draw from the recent case law? Well, the court's decisions remain robust in ensuring that beneficiaries are paid out under letters of credit, regardless of the underlying dispute in arbitration or other courts. But whatever the consequences of COVID-19 for economic interaction and international trade, the English court's protection of letters of credit as the lifeblood of international commerce appears to remain as strong as it always has been. And on that note, I shall hand over to Joe Box, who will consider some of the more practical issues that arise out of the fraud exception.
Again, if there are questions about it, we are going to come back to those at the end of Joe's presentation. Can I just remind those who are taking part in this that if you want to email a question, then please do so to marketing@brickcourt.co.uk, and then it'll be forwarded on to me. And please do ask questions. You've got the chance to interrogate these three people, and I know they're anxious that they should be interrogated. Now on to the third presentation by Joe Box. Joe has a broad practice which covers the full range of commercial litigation and arbitration undertaken in Brick Court chambers. She advises regularly in shipping and international trade disputes, and particularly in relation to letters of credit. She has appeared, indeed, against the last speaker in the expedited commercial court trial and court of appeal hearings in Petro Saudi Oil Services, which you've heard about, a dispute which concerned allegedly fraudulent demands, as you've heard, for the large sum of $129 million under a letter of credit. Well, Joe is going to talk to us now on the practicalities involved in invoking the so-called fraud exception, including applying for an injunction, evidence, putting the bank on notice, and issues on timing. And she will give us some guidance on when all this might lead to success. Joe, over to you.
Thank you, Richard. Following on from Richard Aikens' talk, I'm going to focus today on practical issues that arise when trying to invoke the fraud exception in respect of letters of credit, i.e., what do you do when you think your counterparty has made a fraudulent presentation? In particular, following Richard's discussion of how to resist summary judgment, I'm going to focus on how to injunct the bank from paying out. As Richard has explained, where the bank has notice of fraud on the part of the presenting party, it must not pay out. And I'm going to discuss how one goes about ensuring that it does not do so. The first point to emphasise here is the need for speed. Usually, the bank will be obliged to pay out within several working days of receipt of a compliant presentation. It follows that the window for stopping the bank from making payment is relatively short. Of course, a party will often suspect that its counterparty is likely to make a presentation before it actually does so, especially where a dispute has already arisen. It's important to start thinking about the necessary steps in advance of that presentation where possible, so that you're in the best possible position to actually stop the bank from making the payment before it goes ahead. Once you know or believe that the presentation has been made, there are several important initial steps. First, and this is the most important step, you need to bring the alleged fraud to the notice of the bank. It's necessary to write to the bank explaining the basis for thinking that the presentation has been made fraudulently. If in due course you wish to seek an injunction, one of the things you'll need to be able to demonstrate is that the bank is on notice. It is also possible that the bank will refuse itself to pay out if given proper notice of the fraud. The sooner within the window for payment you provide that notice, the less likely it is that the bank will pay out before the issue has been resolved. Second, you need to request copies of the documents presented, either from the bank or your counterparty, or usually both. It's much easier to draft the necessary court documents with a copy of the presentation, and the sooner you get hold of this, the easier it is to prepare. It may be that the bank will also engage in correspondence with the presenting party in light of the points that you have raised when seeking to put it on notice of the fraud. And again, it's sensible to ask for copies of any such correspondence. Potentially, there's also a third step to take here, which is to seek an explanation from your counterparty as to the basis on which it has been able to make the presentation. There is at least one Court of Appeal authority which suggests that the beneficiary should have been given the opportunity to respond to the allegation, and that having failed to provide any adequate explanation in circumstances where an explanation could be reasonably expected, one is in a much stronger position to seek the injunction. It may be that the bank will decide that it's not going to pay out and inform the parties of that decision after you've engaged in correspondence. However, in my experience, the bank will often wait until the end of the window for payment before making its decision. Accordingly, if you want to ensure that payment is not made, it's likely to be necessary to seek an interim injunction. What should one have in mind when seeking such an injunction in this context? The most important thing, unsurprisingly, is to prepare compelling evidence of the fraud. You need a witness statement from either the solicitor or the client, which explains the basis for the fraud allegation. Ordinarily, one would join both the bank and the counterparty to the proceedings and seek an ex parte injunction. In my experience, parties seeking an injunction will often provide sufficient notice to the bank and the counterparty to enable them to attend the hearing. But given the short timeframes involved, this is generally not sufficient for the hearing to be on notice. Accordingly, the obligations of full and frank disclosure apply. One needs to be careful, of course, in preparing evidence to ensure that those obligations are satisfied. In particular, you must draw to the court's attention any points that might be taken against you. I find that there are often difficult judgment calls to be made here, but generally, it's almost always better to be upfront about the points that might be taken against you, and then, of course, to explain why they should not prevent the court from making the injunction. Failing to identify these points at the outset can lead to significant problems at the return date and down the line. Ideally, if time permits, one should also prepare a claim form and particulars of claim, seeking final relief in the form of an injunction. Sometimes, however, there simply isn't enough time to do this, and if so, you can still apply for an interim injunction and give an undertaking to issue the claim form and particulars of claim as soon as possible. What does your evidence need to establish? Even at the interlocutory stage, a stringent test applies when invoking the fraud exception. The Court of Appeal has previously said that the exception requires established or obvious fraud to the knowledge of the bank, fraud that is very clearly established, and evidence rendering fraud clear and obvious to the bank. The Privy Council has explained that it must be clearly established at the interlocutory stage that the only realistic inference is first that the beneficiary could not honestly have believed in the validity of its demands under the letter of credit, and second, that the bank was aware of the fraud. As mentioned earlier, it has also been suggested that the beneficiary should normally have been given an opportunity to respond to the allegation, although this may not be necessary or indeed feasible in every case. The timing of the fraud is also an important point to consider. Although it has been argued otherwise in recent years, including by PDVSA in the first case discussed by Richard Aikens, in my view, it's reasonably clear on the authorities that the presentation must be fraudulent at the time that it is made. If it becomes evident between presentation and payment out by the bank that the presentation misrepresents the true position in some regard, such that it could not now honestly have been made, that is not sufficient to make the presentation a fraudulent one. Meeting the threshold for the fraud exception can be particularly difficult when dealing with cases where the allegation of fraud relates to a representation of law. This often arises in relation to the sort of payment obligations that Richard discussed earlier. Parties often attempt to dress up an allegation that money is not in fact due as an allegation that the demand on the letter of credit is fraudulent. It is common for letters of credit to require the beneficiary to certify that the sum demanded is due and payable. The other party may then try to argue that that certificate was a fraudulent misrepresentation because the person who signed it did not honestly believe that the sum was due and payable. In Petrosaudi and PDVSA, for example, the trial judge concluded that no sum was due and payable under the contract, and that the interpretation that was put forward by Petrosaudi's general counsel was a lawyer's construct, which he could not really and honestly have believed. On that basis, the fraud exception was made out. However, the Court of Appeal held that the interpretation that His Honour Judge Waxman had considered so clearly wrong as to be fraudulent was in fact the correct interpretation. Lord Justice Christopher Clark expressed disquiet at the finding of fraud. He said, whilst there is only one true construction of an instrument such as the certificate, different legal minds may obviously take different views on such a question. And he noted the difficulty in finding that what was in essence a representation of law was fraudulent. Accordingly, if one is dealing with a representation of law, as in that case, one needs a particularly strong basis for alleging fraud. Generally, it will not suffice that there are different potential interpretations of the legal position. It's necessary to show that there's no basis for the legal interpretation relied on by the presenting party. The final point that I would like to note today is a development that I've encountered several times in recent years. There appears to be an increasing tendency for a party seeking an injunction to make an alternative application for payment into escrow. Generally, this is worse for the party making the application than an injunction against payment out by the bank. For example, if payment out is made into escrow, obligations to replenish the letter of credit are still likely to be triggered. However, this may be a particularly appealing fallback option in cases where the presenting party has very limited assets, and there is a real risk that following the resolution of the underlying dispute, it will not be possible to recover any money paid out. The legal basis for seeking payment into escrow is not straightforward. In particular, it might be said that an order for payment into escrow in these circumstances is effectively freezing relief without meeting the high threshold for freezing injunction and without the protections inherent in a normal freezing injunction. For example, in the cases I have seen, no equivalent provision is generally provided for ordinary business expenses and legal expenses. Indeed, in some cases, the concern appears to be that the party will spend the money on its ordinary business expenses. Nonetheless, this fallback application is a point to consider if you're making an injunction application to prevent payment out by the bank. In particular, it's always possible that the counterparty will consent to payment into escrow to preserve its position if it is concerned that payment out might otherwise be injuncted. And this is especially likely to happen if there are concerns about the expiry of the letter of credit. In the last couple of months, I have seen a number of cases of parties trying to invoke the fraud exception, and it seems likely to me that there will be more of these in the months to come, especially in light of the current market conditions and some of the points highlighted by Richard Lord earlier. It's helpful to have in mind the necessary practical steps as soon as any dispute arises to ensure that you're in the best position to protect your client's interests. I'm now going to hand back over to Richard Aikens so that we can all address any questions that you have arising from today's talk. As Richard mentioned earlier, if you do have a question, please do send it to marketing@brickcourt.co.uk and we will do our best to answer any such questions. Thank you very much.
Joe, thank you very much indeed for that very clear exposition. Now, at the moment, it appears that nobody has been brave enough to put forward some questions. So in those circumstances, I'm going to, as it were, step into the breach. But can I please encourage anyone who does want to ask a question to think about it, put it in the email, as Joe has just said, to marketing@brickcourt.co.uk. And even though we will finish the webinar after the brief discussion we're about to have now, I'm sure that the participants will only be too happy to answer any questions that are sent in afterwards. And indeed, in the last webinar that I chaired, there was a question that somebody even wanted me to answer. But it looks as though, whilst I have been just talking, a question has arrived. So let me read this out. It's a question from Sam Fowler Holmes, who asks the following. Given the limited time frame for seeking an injunction, what protection is there for a bank who has been notified of a potential fraud, but where no injunction has yet been obtained, and the time for payment under the instrument occurs? If it withholds payment and the fraud is later not made out, is the bank exposed to liability for not having made the payment? Well, who would like to deal with that? There's really two aspects to that question, perhaps a procedural one and a substantive one. Do you want to consider that first, Joe?
Absolutely. The bank is almost always in a very difficult position in that situation because they are liable if they don't pay out when there's been no fraud. But equally, if it turns out in due course that there was a fraud, they shouldn't have paid out. Generally, in my experience, banks will take legal advice on the point, but also will usually write to the presenting party as soon as they're put on notice of the fraud, seeking more information, and ideally putting themselves in a position where they can take an informed view as to whether or not fraud is likely to be made out in due course. But I would agree that in many respects, the bank is in a better position if a party applies to injunct it from making payment, because then it can rely on the court's guidance as to what to do.
Yes, I would echo Joe's point on that. In a sense, the bank wants the protection or the blessing of the court as much as the beneficiary. And so the bank is likely at any hearing probably to take a neutral position and for the dispute to be fought out between the beneficiary and the other party. But the bank probably wants to get itself before the court as much as the beneficiary.
Well, now, what about the second part of the question? The bank decides it's going to withhold payment, but then the fraud is later not made out. So although at the interlocutory stage, there is apparently compelling evidence of the fraud such that there's a real prospect that the only reasonable inference was that the fraud exception applied, ultimately that doesn't happen. Is the bank then exposed to liability for not having made the payment? And if so, is there any way that it can try and protect its position? Any thoughts on that, Richard or Joe, or Richard Lord, indeed?
I'm happy to go first.
A fast ball.
There's no enthusiasm coming from the other members of the panel to rush into that question. Obviously, there are a number of somewhat complicated points of law that one has to bottom out in that situation, and a lot will turn on the specific facts, but also the provisions in the letter of credit itself, and potentially also in the contract that the bank has with the applicant for the letter of credit.
Yeah.
Generally, if the bank has been injuncted by the court from paying out at the interlocutory stage, and then it later turns out that that injunction was inappropriate, in general terms, whilst the bank at the later stage would then have to pay out, my understanding is that the bank wouldn't necessarily be subject to any additional liability. If there's been no injunction, the bank is in a more difficult position because it hasn't simply acted in accordance with the court order. It's made its own decision not to pay out. And depending on the facts, there is potential for exposure there. Yeah. And I think those are the sorts of cases where the bank is best advised to get as much information as it can I've never actually seen a case where the bank sought the court's guidance itself, but I suppose in a difficult case, in theory, it could do so. And it may be that if the potential exposure is very significant, that's something the bank should itself consider.
Okay.
I mean,
Richard,
it seemed to me that there would be a question that, well, what actually is the exposure of the bank? And the best way to minimise exposure would be to have an expedited trial, so that the issue could be determined as soon as possible, so that if there is any exposure, it can be minimised.
Yes, I'd only add to that the bank is in a difficult position, but the authorities do seem to make it clear that the bank's under no duty to conduct its own investigation. Obviously, it may be put on notice of some things that are so obvious that to ignore them would be blind eye knowledge, but it doesn't mean that the bank has to undertake a detailed investigation. It's only if, on the face of the evidence presented to it, there is clear evidence of fraud that it can justify not paying out.
Thank you. Now, another question has arisen, and it's something which I think applies to the circumstances that all three of you have been talking about, where you want to get injunctive relief in a hurry. And I'm going to link this question, which comes from Stuart Shepherd, an old colleague in the sense that he's been a colleague of mine for a long time. That doesn't make him old like me. But Stuart asked this question: could someone discuss the balance of convenience issue in relation to the court granting injunctions restraining payment under a letter of credit? And can I link that with a point that occurred to me? Are there any particular rules or practices that apply in relation to injunctions for letters of credit, in relation to cross undertakings as to damages? Richard Aikens, do you want to deal with that first in a general sense?
Yeah, so as regards to cross undertaking, I don't think there are any sort of particular rules as regards particular specific rules that regard cross undertaking. And as regards the balance of convenience, I mean, in one sense, when it comes to letters of credit, it's slightly different, because the bank has to pay out unless it has clear notice of the fraud. So in that sense, the question of balance convenience it doesn't really arise. Obviously, it's always there is a discretionary factor like any injunction, but I think in general terms the rule is the bank has to pay out, rather than looking at questions of balance of convenience. And that's perhaps another reason why you want to have an expedited trial or some sort of expedited hearing, so that whatever the balance between the competing interests, it can be resolved as quickly as possible for basically a final injunction to be given or not.
Now, in the case in which both you and Joe were involved, was an expedited trial, was it? And how expedited was expedited?
So we were in court, I think, on a Thursday or Friday for the interim injunction hearing, and His Honour Judge Waxman, as he then was, ordered the expedited trial to occur the following week. That presented its own difficulties, and with the benefit of hindsight, a slightly longer gap between that hearing and the expedited trial probably would have been more sensible. But the commercial court certainly is willing to expedite these matters. That was also something that arose during September, during court vacation.
Right.
So the court has shown that where something is pressing, and in particular, there were facts in that case to do with the risk of insolvency on the part of PetroSaudi that made it necessary for this to be resolved sooner rather than later. The court will take the necessary steps to do that if it possibly can.
Well, particularly in that case where the sum involved was so large, 129 million. Okay, now Richard Lord, a question for you from Daryl Kennard, and it's quite a specific one. Can a carrier seek to defend a claim by a bank under a bill of lading for non-delivery of cargo if it, that's the carrier, can show the bank had knowledge from historic trading patterns of their customer that delivery would be against an LOI rather than against surrender of the bill of lading?
Thanks, Daryl. Well, in the absence of cricket, that's probably the closest we'll get to a fast ball today. But I think the basic answer is in theory, but it's very difficult in practice. And this came up, I think, in some of the Avanti Rushi litigation. But it's very difficult because normally the analysis is, even though everyone knows these things are going to be delivered against LOIs, it's very hard on the facts to show a waiver of the right of the bill of lading holder to sue in conversion anyway. So the short answer is I'm not aware of cases where that's been successful, although the defense has been invoked a few times. So possible but difficult is my take on that one. The chairman may have views on that as well. Well, the others may, but particularly the chairman may.
I think I don't particularly have views on it. Joe or Richard, do you want to add anything?
Nothing from me, no.
I agree with Richard's analysis.
I sound a bit like the politician in the middle of those press conferences that we've been listening to every day, asking the scientists if they've got anything to add, thinking that the scientists probably know a lot more about the subject than he, the politician, does. But never mind, let's move on to another question we have. This is from Ian Goulson. And it's more of a comment than a question. In respect to the question as to how the bank may protect itself should it be found liable to pay damages for failing to honour the letter of credit, could it not claim against the party putting it on notice of the potential fraud for the tort of procurement of a breach of commercial contract? Now, what about that one? What do you think? Joe, what do you think?
Certainly a very interesting suggestion. I think something that, if the facts were right, one could potentially pursue. In this scenario, a lot will depend on the contract between the bank and the applicant for the letter of credit. And I've seen a number of inventive arguments, particularly recently, by lawyers on behalf of the bank as to what that contract provides and doesn't provide. And in one case, a suggestion that somehow that contract meant that the fraud exception didn't apply at all, which seemed to me surprising and not very persuasive. But I think in that situation, there may well be some sort of indemnity or other provision within that underlying contract that the bank can rely on. And if it doesn't, I think some of the economic torts are potentially an interesting argument to advance, and possibly one that might have some purchase.
Okay, but Richard, did you want to add anything? Richard?
I agree with Joe. It's a very interesting approach and possibly fruitful in certain circumstances. I mean, I think a point that Richard Lord made a few moments ago, of course, the bank isn't under any duty to investigate as such. I mean, if it's clear, if the documents are clear, and now that it is also clear from the Court of Appeal that it doesn't matter whether actually the beneficiary is entitled under law to make the demand, in many ways the bank's task is actually pretty simple. And so if the bank does have concerns, and yes, I suppose in theory, bringing some sort of action against the person who tried to put it on notice might bear fruit. But I think it's always important to remember that the prime position of the bank will be pay out.
Yeah. Okay. Well, I think we've now come to the end of our hour, and I haven't had to invent some questions for any of the speakers. So thank you to all those who have put in questions. And I repeat again, if there are other questions that come to your mind now, then as the saying goes, put them on an email and send them to the address that I've given you, and we will try our best to answer them. May I, on behalf of everyone, thank all our three speakers for their very eloquent but succinct presentations today, and wish you all a happy Friday afternoon and a good weekend. And let's all hope that the lockdown is continuing to become less oppressive as the weeks go by. Thank you all very much indeed.
Thank you. Yes, goodbye, everyone. Thank you.